And thanks to At Home for joining us this hour. In 1974, Leon Jaworski was the special prosecutor who was investigating Watergate and related issues within the Nixon administration. The first special prosecutor, of course, had been Archibald Cox. President Nixon had to fire his way through the upper echelons of the Justice Department in order to fire Archibald Cox, the first special prosecutor, for him having the temerity to demand that the Nixon White House follow law and obey court orders and hand over material relevant to that investigation. So Cox got fired. Leon Jaworski was Archibald Cox's successor. And if the Nixon White House was hoping for somebody to be intimidated by how he got the job, if they were hoping for somebody more cowed, somebody who'd be less aggressive, somebody who might have felt at least implicitly threatened by the way Archibald Cox had been ousted on direct orders from the president, that was not what they got with Leon Jaworski. Leon Jaworski was just as rock-ribbed, just as straightforward, just as unintimidated. And 45 years ago this month, Leon Jaworski assembled this 62-page document summarizing material that the Watergate grand jury had obtained that was relevant to understanding the president's own conduct within the Watergate scandal. Now, grand juries conduct their work in secret. It is absolutely integral and sacred to the grand jury process that the evidence they obtain in the course of an investigation be used for one purpose and one purpose only, which is drawing up indictments. That's all grand juries do. The information that goes to them can't be used for any other purpose. However, when a grand jury collects information that is relevant to the potential criminal misconduct of a sitting president of the United States, it has long been Justice Department policy, even in the Watergate era, that in that instance, the end product of the grand jury's work can't be an indictment. A sitting president can't be indicted. And so what's a grand jury supposed to do with the evidence it collects about criminal activity by a sitting president? Where does that information go? I mean, when a prosecutor conducts grand jury proceedings that turn up evidence that indicates potential criminal activity by a sitting president, that prosecutor has to figure out, right, what to do with what this grand jury has just learned about the president's behavior. In Leon Jaworski's case in 1974, with the Watergate grand jury he had convened in 1974, what he decided was that it just would not do for that information about the president to drop into some black hole of presidential immunity from prosecution. And so Leon Jaworski's grand jury in March 1974, they obtained permission from the federal court in Washington, D.C. to transmit the evidence that they had obtained to Congress, the evidence they had obtained that was relevant to Richard Nixon's criminal behavior as president. That 62-page document was not an indictment. They did not try to bring an indictment against President Nixon. What they did was present the factual record that they had amassed. This was a 62-page document. It was essentially a guide. A lot of people called it a roadmap to the hundreds of documents and multiple tape recordings that grand jury had obtained and reviewed and come to see as relevant to the president's potential criminal actions. They packed up all that evidence. They wrote up this terse document summarizing that evidence, giving Congress the salient information they thought Congress would need to be able to make a decision about what to do next. There were no recommendations as to what Congress should do. There were no conclusions drawn as to whether or not the president had committed crimes. It was just the facts, just the factual record. And in the end, Congress did decide to use that roadmap of evidence collected by the grand jury as the basis for their impeachment articles against Richard Nixon, first and foremost on the basis of his alleged obstruction of justice. And while grand jury information really is supposed to be secret, and it is therefore a big deal that that court cleared it for that grand jury information to be conveyed to Congress in 1964, it's interesting. That 62-page document containing all that grand jury information about the president, it never leaked. It was conveyed by the grand jury, by Jaworski's grand jury, to Congress, to the House Judiciary Committee. It was kept confidential by the House Judiciary Committee, even as they used it to draw up the impeachment articles against Nixon. It was never leaked to reporters. It was never leaked to the public. The only reason we can look at it now, 45 years later, is because just within the past year, the court decided it was finally okay to let it be seen basically as an object of historical interest. And so finally now we can read in that original document, all these years and decades later, about what evidence there was about President Nixon obstructing justice. And, it is remarkable to see it all, typed up in terse. There he was on February 20, this item 41. February 28, 1973, there was Nixon meeting with John Dean, talking about offering presidential clemency to the Watergate defendants. And we know from the footnote there, 41.1, that there was a tape recording of that meeting, and that's how the grand jury knows that that conversation happened and what they discussed. Then a few pages later, we get to item 45, which tells us that 3 months after that conversation he had with John Dean about offering clemency to the Watergate defendants, Nixon says in a public statement, quote, "At no time did I know about any offer of executive clemency for the Watergate defendants." And what is the source of that information? Well, that's a thing the president did in public. They sourced the transcript of a Q&A session by President Nixon with Associated Press managing editors. And putting out those two pieces of information in that document, that was not Leon Jaworski, the special prosecutor, or his grand jury saying, hey, the president appears to be obstructing justice here. He knowingly lied about whether or not clemency was going to be used as a tool to try to cover up the Watergate break-in. They never spell it out like that. They just laid out the facts and how they knew those facts. That was just Jaworski and the grand jury saying, this is what we know about the president's behavior. Here is the documentation that proves it. You make the call as to what to do about this. And the you making the call in that case was Congress. Leon Jaworski and that grand jury was not going to indict the president in a court of law. So they got permission from the court. It was Congress's decision what to do with the factual information that they had amassed. No recommendations from that grand jury and from the special prosecutor. No conclusions drawn, just the facts. That is our historical inheritance as a country, as a people, in terms of how we deal with presidential wrongdoing. And now, to celebrate the 45th anniversary of that on-the-nose historical precedent for an investigation into potential obstruction of justice by a sitting president of the United States. Now, 45 years later to the month, now this time, the Trump administration has decided they'd like to handle this one a little bit differently this time. In a 4-page letter to the Judiciary Committees in the House and the Senate, newly appointed Attorney General William Barr has written a short narrative description of the content of the final report that has been prepared by Special Counsel Robert Mueller, a final report which no one outside the upper reaches of the Justice Department and the Special Counsel's office has apparently seen. In what Barr describes as an initial review of Mueller's report, he starts off by describing the reach and the effort put into Mueller's investigation. Quote, in completing his investigation, the special counsel employed 19 lawyers who are assisted by a team of approximately 40 FBI agents, intelligence analysts, forensic accountants, and other professional staff. The special counsel issued more than 2,800 subpoenas, executed nearly 500 search warrants, obtained more than 230 orders for communication records, issued almost 50 orders authorizing use of pen registers, made 13 requests to foreign governments for evidence, and interviewed approximately 500 witnesses. And boy, that's a lot of numbers. Those certainly seem like an impressive list of numbers of things. It would be more substantively illuminating to the American public and to Congress if we knew anything about the products of those 2,800 subpoenas, or what those 13 foreign governments turned over when they got requests for information. It would be more substantively helpful to know what kind of information was obtained from these 500 witnesses. But nevertheless, I think those free-floating numbers are up there at the top of the letter in order to make us feel assured that no stone was left unturned. Barr then describes what he says are the two parts of the special counsel's report. The first is the special counsel's investigation into Russia's interference in the 2016 U.S. presidential election. From what Barr says in his short letter, it sounds like the actual Mueller report goes into quite a bit of detail about what Russia did to try to mess with our election and try to install their favored candidate in the White House. Barr then says, and he repeats himself for emphasis, he then says that, quote, the special counsel's investigation did not find that the Trump campaign or anyone associated with it conspired or coordinated with Russia in its efforts to influence the 2016 U.S. presidential election. So that's the first part of the report. He quotes what he says is a sentence from Mueller's report, that there was no finding that the Trump campaign or anyone associated with it conspired or coordinated with Russia. That's the first part of the report. When it comes to the second part of the report, when it comes to obstruction of justice, one of the things Barr appears to be vaguely hinting at here is that Mueller seems to have made some sort of detailed factual accounting of the president's actions that could potentially be construed as obstruction of justice. Barr says that Mueller made a, quote, thorough factual investigation into these matters related to obstruction of justice. He says, quote, for each of the relevant actions investigated, the report sets out evidence on both sides of the question and, quote, leaves unresolved what the special counsel views as difficult issues of law and fact concerning whether the president's actions and intent could be viewed as obstruction. More broadly, William Barr describes, quote, the special counsel's decision to describe the facts of his obstruction investigation without reaching any legal conclusion, which is something that has some echoes in history. Right? Factual information about the president's behavior as it relates to obstruction of justice. No conclusions one way or the other as to the criminality of those actions, just that detailed factual information handed over without recommendation, without drawing prosecutorial conclusions. That is what Leon Jaworski and his grand jury did on March 1st, 1974, in that document that was conveyed to the House Judiciary Committee. And we don't know exactly what Robert Mueller has done, because all we have is William Barr's short and somewhat opaque description of what he says Mueller has done. But what Barr seems to be indicating here is that he got a detailed, just the facts recounting of Trump's behavior that potentially pertains to criminal obstruction of justice. A recounting that, quote, does not conclude that the president committed a crime, but it also does not exonerate him. And when that exact sort of document was handed over to the Judiciary Committee in the House by Leon Jaworski and the Watergate grand jury in 1974, the Judiciary Committee in 1974 looked at that factual record of information they had obtained from the grand jury and the special prosecutor, and they decided, in fact, that based on that information, they would draw up impeachment proceedings against President Nixon, primarily for obstruction of justice. This time, this factual record, this description of the president's behavior, it didn't go over to the House Judiciary Committee. Instead, they got a letter, because the actual information went instead to the president's newly appointed attorney general, who has been on the job for a month and who got the job after submitting to the White House an unsolicited 19-page memo which claimed that the president inherently can't obstruct justice and Robert Mueller can't even investigate him for that. Whatever information Attorney General William Barr just received from Robert Mueller about the president's behavior as pertains to potential criminal obstruction of justice, Barr could have just passed that information onto the Judiciary Committee for them to decide what to do with it, following in Jaworski's footsteps in the handling of the Watergate roadmap in 1974. But instead, somewhat inexplicably, he decided to take it upon himself to declare definitively, yeah, you know, I looked at all that stuff and I can tell you there's no crime there, it's fine. At which point, whatever you think about the quoted conclusions about the other half of Robert Mueller's report, on this obstruction stuff, it's like, where did this come from? I mean, on what grounds are you saying that you have concluded there's no crime here? What facts did you consider about the president's behavior when arriving at that conclusion? Mueller did apparently provide a detailed factual description of the president's actions as they pertain to obstruction of justice, including some actions that Barr says were not publicly reported. But we apparently will not be allowed to see that material. And the Attorney General seems to be indicating that Congress won't be allowed to see it either. Only he gets it. I mean, to the extent that Mueller amassed a factual record of the president's behavior, some of it will be stuff the president did in public that we can all read about in the paper. But other stuff, especially stuff that wasn't publicly reported, he presumably would have pursued through the grand jury process. Right? Those 2,800 subpoenas, in large part, those were likely subpoenas to provide evidence and information to the grand jury. There were interviews with hundreds of witnesses. And some of those witnesses may have been directly interviewed by the special counsel's office, and that's it. But witnesses were also brought, a lot of witnesses were also brought before the grand jury. Attorney General William Barr now says at the end of his short letter to the Judiciary Committees that while he would love to convey Robert Mueller's confidential report in its entirety to Congress, and he is, quote, mindful of the public interest in this matter, oh, sad trombone, he can't, because he needs to remove all grand jury material from the report before he allows anybody else to see any of it, including the Judiciary Committees in Congress. And again, grand jury information rightfully is kept secret, but it is kept secret for a reason, which is that grand juries collect information for the purpose of considering criminal indictments against criminal suspects. When a grand jury has collected information against the one person in the country who can't be indicted as a criminal suspect because of his job, because he's the president, well, does that grand jury information about the president just go into a burn box somewhere? Or does it go in confidence to an entity that can pursue justice and accountability for known criminal acts, even when an indictment can be brought? I mean, Jaworski and the grand jury conveyed their information in secret, under seal, to the Judiciary Committee in 1974. This information, obtained by Mueller's report, apparently just goes to President Trump's appointee. And other than that, he's going to make sure nobody else sees it. The surprise in William Barr's letter this weekend about Mueller's findings, the big surprise was this strange assertion, a legitimately unexpected assertion about Robert Mueller, the special counsel, choosing to, quote, not make a traditional prosecutorial judgment as to whether or not the president committed crimes related to the obstruction of justice. And that looms the largest in all of the questions raised by William Barr's report. Right? We do not have the Mueller report. We have less than 50 words that Barr says are quotes from the Mueller report. Other than that, we've just got William Barr's statement. And William Barr's statement, we can call it the Barr report. It raises all sorts of brand new questions we didn't have before about what exactly is going on here with this investigation and what fruits it will be allowed to bear. I mean, first and foremost, question one. The special counsel's office, according to Barr, determined not to make a traditional prosecutorial judgment on obstruction of justice. Well, why did Mueller make that determination? And was it in fact a choice? Did Mueller believe that he had a choice in that matter, or did he believe he was constrained either by his legal remit or by Justice Department policy? I mean, Barr, in his report, describes this decision by Mueller almost in wonder, like, who knows what this Mueller guy was thinking? He just decided not to do this part of his job. Weird, right? And so that has led to a whole day plus of speculation and news reporting now as to what this crazy guy Mueller must have been thinking when he did that. Well, all we have here is Barr's assessment of what Mueller did. Mueller was reportedly not consulted on the Barr report and how Barr characterized Mueller's decision here, nor has the special counsel's office commented one way or another on Barr's report since it was released. And so we don't know. But if Robert Mueller believed, like Leon Jaworski and his grand jury did in 1974, if he believed that his role was to lay out the facts that pertain to the president's alleged criminal behavior without making recommendations or drawing conclusions one way or the other as to whether or not that behavior constituted a crime, well, that makes it all the more remarkable that Attorney General William Barr then jumped in and said, I know what the answer is. I know what the answer is here. I'll do it. I'll decide. So that's question one. Question two, it relates. Did Robert Mueller expect the Attorney General to jump in and make a no prosecution announcement regarding obstruction of justice? Did he ask him to do that? Did he expect him to do that? Or was that as much of a surprise to Robert Mueller as it was to the rest of us? Third question, and it relates. Is it proper that Attorney General William Barr would make this kind of a public call, especially upon receiving no recommendation from the prosecutor who helmed this grand jury and otherwise conducted this investigation? Is there anything in the special counsel regulations or in Justice Department regulations more broadly that direct the Attorney General to jump into the breach here and say, hey, I personally have decided after looking at this for a day that there's definitely no crimes. I've decided it's my role to make that public pronouncement. Was that a proper role for the Attorney General, and on what basis did he make that public pronouncement? Fourth, one of the reasons it might not be proper for a prosecutor, for any prosecutor, or for the Department of Justice more broadly, to jump in and make a pronouncement that a president appears to have committed crimes is because of the possibility that that president could actually be indicted and prosecuted and put on trial for those crimes after he or she has left office. So let's say, like, just as a lark, that a president directed his longtime personal lawyer to commit campaign finance felonies right before the 2016 presidential election. And prosecutors are sending his longtime personal lawyer to prison for that. And they think they've got the president himself dead to rights for having directed the commission of that felony. And prosecutors are willing, let's say, to bring charges and mount a trial to prove it in a court of law. But they can't do that while the president is serving as president. So, say they plan to do that. They plan to try to secure that indictment against the president starting the day he leaves office. That kind of a scenario might conceivably be a reason why a prosecutor and why the Department of Justice more broadly would not want to go on the record publicly declaring whether or not some behavior by the president amounts to a crime. Because that sort of pronouncement from a Justice Department prosecutor or the Justice Department more broadly would taint the deliberations of any grand jury that was asked to consider whether an ex-president committed a crime and should be indicted as such. So is that a reason why Robert Mueller might not have said one way or the other whether the president's actions constituted criminal obstruction of justice? So as to avoid essentially precluding any future prosecution of the president for crimes that he may have committed once he leaves office. And if that's why Mueller believed, if that's why Mueller believed that he was not supposed to say one way or the other whether this was a crime, if that's why he believed this was supposed to be just the facts, ma'am, other people should come to their conclusions about whether or not this is a crime. If that's why Mueller was reticent on that point to give any recommendation, to pronounce any conclusion, make any prosecutorial announcement, if that's why Mueller was holding back on that, did William Barr blow that up? When William Barr decided to land with 2 feet on one side of that question and say, as far as I can tell, there's no crime here. I hereby proclaim no crime. In so doing, did he just screw up any future grand jury proceedings that Mueller might have been trying to protect? We're only up to question 4. Oh, hold on. I am just getting started. Stay with us.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.